Good morning, everybody. We'll give everybody a couple seconds to get into the webinar to talk a little bit about our legislative session. We're in the midst, 87th legislative session, halfway update.
Good morning, everyone. Thank you for attending today. So we do have a lot of information for you. There's been a lot of bills that have been filed affecting POAs and then also potentially affecting POAs. Today, we will be going through these bills quickly. However, you do have the option of in the chat box asking any questions you might have, and then whenever you see them pop up, we'll have the opportunity to answer those during the presentation. My name is Paul James.
Yeah, let's go ahead and get started. So I'm your host, Clint Brown. I'm an equity shareholder with our firm, Roberts, Markell, Weinberg, Butler, Haley, out of Austin. You have with us Paul Gaines as well. Paul is an attorney out of San Antonio, Texas, and he is actually a board member on TCAA, Texas Community Association Advocates. He'll be talking about Rally Day here in a minute. So with that, let's get into it. As Paul mentioned, we have got a ton of legislation to address today, so we are going to be going a little quick. That doesn't mean you cannot type in your questions in the chat box as we move through our bills. Here is our disclaimer. Information presented today is based on the law as it exists as of today, March 23rd, 2021. As you know, or probably guess, there are a multitude of bills that have been introduced affecting community associations. We are not going to be addressing every single bill. We have tried to highlight some of the more important bills. That doesn't mean other bills are not important. It just means we didn't have time to hit on them. So it's for educational purposes only and does not constitute legal advice. Paul and Clint are not giving you legal advice today. Rather, we are just discussing the bills that are on the table. And if you need legal advice relating to any of these topics, please consult with your attorney, whether that be our law firm or another law firm. So here are some key dates for our 87th legislative session. On November 9th, the pre-filing began of last year. First day bills were filed for the 87th legislative session. January 12th, the legislature convened. March 12th was the 60-day bill filing deadline. That was the drop dead date. And then finally, May 31st of 2021 is the last day of the 87th regular session. That means things are going to be getting a lot hotter. We're going to see a lot more meetings, committee meetings, votes both at the House and Senate level. So, you know, if you've been watching it, just know that between now and the end of May, there is going to be a lot of action regarding a lot of these bills we're going to be discussing. So with that, I will turn it over to Mr. Gaines. Paul.
Thanks, Clint. So this session is unlike any other session we've seen before. With COVID-19, the ongoing pandemic, a lot of what we're seeing is going to be virtual. Of course, there's a lot of things that are kind of up in the air whenever it comes to what's going on in the Capitol in Austin. A lot of the senators and representatives are doing things virtually. However, some of them are doing things in person as well. So at this time, there's no real standard plan whenever it comes to all the testimony and committee hearings that are necessary for the progression of these bills. A lot of the staff is working remotely. As you can see, Clint and I are working remotely as well. So the procedures, practices, and decisions, again, this is all going to be based on a lot of virtual testimony as well as everybody working remotely. The committee meetings have started. As Clint stated, March 12th was that bill filing deadline. Now we're seeing these bills pushed to committees and they are live. And now let's touch a little bit on Rally Day. So as Clint mentioned, I'm a board member for TCAA, Texas Community Association Advocates. And what we do is that we support or oppose legislation whenever it comes to the POA industry. We try to work with the legislators to support or again oppose some of these bills that may have an impact whenever it comes to actually passing these in the House or the Senate. And Rally Day is actually starting this week. So yesterday we did have our check-in and opening session to give y'all some dates on the different CAI chapters that we will have for the next 4 days. This will be Austin, Dallas, San Antonio, and Houston. We'll be working with legislators to discuss some of the highlights of some of these bills and essentially try to explain why we support or oppose the language within these bills. To give you all some dates, today from 1 to 2 p.m. will be the Dallas-Fort Worth CAI chapter legislator meeting. Tomorrow from 1 p.m. to 2 p.m. will be the Austin chapter meeting. Thursday from 10 to 11 will be San Antonio, and Thursday from 1 to 2 will be the Houston chapter. And on Friday from 10 to 11, we will have a virtual legislative meeting debrief, closing session, and also a federal update. If anybody on the presentation today is interested in getting involved in signing up or registering for Rally Week, please let me know. We can give you the details. Please email me personally, and I'm happy to give you all the information we can. Again, please note that this is happening this week. So if you want to get involved, let me know as soon as possible, and we can get that going. So let's roll into all the POA bills that have been filed.
And hey, before you start, a good comment was made. Paul and I accidentally mentioned using the chat function. Instead, use the Q&A function. So I apologize for that. Use Q&A for your questions.
Thanks, Clint. So we have seen a lot of bills filed regarding discriminatory or unconstitutional provisions. There's been 4 or 5 with many companion bills, and this is a hot topic for this particular session. One of the first ones that was filed was House Bill 485. This is relating to the removal of certain unconstitutional provisions from real property records. It was introduced by Representative Wu. This permits an owner of property to file suit to remove from a recorded instrument affecting or conveying an interest in the property, which arguably would be the declaration as well. Provision that violates the United States Constitution, is unenforceable under law, and is unambiguously discriminatory. Now, the intention of this bill is good. You know, if you have discriminatory provisions out there, you want to get those removed. Currently, of course, under current law, those would be unenforceable, but this gives a procedure to essentially remove that from the document. However, the issue with this one is that it does not involve the membership, and it doesn't involve the board. So you can go in, you can file this suit, and at the end of the day, the board or other members of the community might never know if there was a judgment permitting the redaction of this particular provision. Senate Bill 222. This is also relating to discriminatory provisions in documents that affect real property. This would permit an owner to request on a form provided and created by the Attorney General that the county clerk remove a discriminatory provision or a restriction. And luckily, it does state, as defined by Section 5.026 of the Texas Property Code, from a recorded instrument. Now, if it is determined by the clerk that it is discriminatory, then the clerk would be the one to remove that particular provision. This one has got issues written all over it. First off, the clerk should not be the one to determine whether or not this is a discriminatory provision. From what we have heard, people who are advocating for clerks already don't want to do this anyways. It just adds more stress to their job. Unfortunately, this particular bill does have legs. It's moving. We believe that it does have support in the Senate. So we will be watching this one very closely and providing updates on any progression of this bill.
And I think, Paul, on this one, a lot of the clerks are opposed to that bill,
Yes,
just because they don't want to take on that responsibility. I mean, it's kind of like asking a pediatrician to comment on a heart condition. They don't specialize in interpreting HOA governing documents. So it doesn't make a lot of sense.
exactly. And going back to it, it just makes it so easy for somebody just to fill something out, and then a clerk might say, okay, this is discriminatory. Well, at the end of the day, we still need the board. We need membership involved. This could redact a provision in a declaration, and the board and the membership would never even know that it occurred.
What's a typical example? We've got a question from our audience, Paul. What's kind of a typical example of something that would be discriminatory in a set of restrictions?
Well, some of the very older subdivisions might have discriminatory provisions regarding, who may live there, maybe even race provisions. And, in my career, I've only seen maybe one or two, and they're very, very old subdivisions and declarations. Arguably, other people might say that the right of first refusal might be discriminatory. That's just an argument that you might hear. And this is where we get into the weeds of what some people believe is discriminatory and what some people believe is not. But yes, in my career, only one or two of the very ugly ones and the very old subdivisions will you see that are really on their face discriminatory. And we actually have a bill that we will discuss here in a little bit regarding older subdivisions and their ability to remove those discriminatory provisions. So next we have House Bill 1483. This is relating to the redaction of an unconstitutional restriction from an instrument conveying an interest in real property. As you can see, a lot of these bills are similar. They're all trying to get the same job done here. The bill would permit a grantee of an instrument conveying an interest in real property who believes that a restriction and the instrument violates the Texas or U.S. Constitution to bring an action against the county to seek the redaction of the restriction. If the court did find the restriction violates the Texas or U.S. Constitution, the court has to enter a judgment that identifies the specific language and then requires the county clerk to redact it. Again, this one does not involve the membership, it does not involve the board. It is simply one individual going to court trying to remove one of these restrictions. House Bill 1202 with the companion bills here, Senate Bill 754 and Senate Bill 602. This is the best one we've seen regarding redaction of discriminatory provisions. So this is relating to the amendment of a dedicatory instrument to remove a discriminatory provision. And what's different about this one is it does provide plenty of different avenues to remove this discriminatory provision. It takes into account some of those subdivisions that might have restrictions, but not an association. So it provides a procedure for the governing body of a POA to amend a dedicatory instrument to remove a discriminatory provision by a majority vote of the governing body, one on its own motion or on the motion of a member of the POA. So it involves both the board and the membership, provides those two different avenues. It also provides that you can petition to remove the discriminatory provision, and then also has an amendment committee formation process for the removal of that discriminatory provision. So again, if you have one of those unique subdivisions that has restrictions, but no association, this does provide an avenue for that amendment committee formation process.
All right. So before we get out of the discrimination, I want to make it clear, just because there is a provision in the restrictions does not make it legal. So we want to make it clear that most associations understand that the discriminatory provision is not enforceable and is not legal. This just allows for a process for the board to fix the problem, or an owner, whatever bill we're referring to. So I just want to make that clear. It is clearly not legal. It's just stuck on the books, and this is a way to get it removed from the restrictions. So we had a couple questions on that. So let's move over to Texas fair housing bills. We've got House Bill 188, Senate Bill 233, and House Bill 191. And it's relating to the prohibition of certain discrimination based on sexual orientation, gender identity, or expression. So it basically adds these to, gender identity or expression and sexual orientation to the protected classes list under Chapter 301 of the Texas Fair Housing Act. So, it just adds some more protected classes. And the HUD, in February of 2021, HUD announced that it would enforce Fair Housing Act to prohibit discrimination on the basis of sexual orientation and gender identity. So basically, if it passes, it's going to add those protected classes. House Bill 875, this relates to prohibition of housing discrimination on the basis of age or certain housing needs. And again, it adds age and housing needs to protected classes. So again, another bill that adds some more protected classes under the Texas Fair Housing Act. House Bill 1470 and Senate Bill 265. This relates to prohibition of housing discrimination on the basis of a person's source of income. So when you're using kind of housing choice vouchers under Section 8, kind of Section 8 housing idea, or any other kind of federal or state or local housing assistance, this prevents you from discriminating when you find out about that source of income.
Okay, emotional assistance animals. House Bill 801, relating to a certification program for assistance animals and authorizing a fee, also imposing a civil penalty. This was introduced by Cortez and establishes a certification program for assistance animals in Texas, including but not limited to obedience training, evaluation by a licensed veterinarian, and evaluation on the primary owner by a mental health professional. This does establish a statewide assistance animal registry and would prohibit assistance animals in common recreational areas over 55 communities unless the assistance animal is certified and meets the additional requirements under the bill. So the idea of this bill is great. As many of us have experienced in the POA industry, especially emotional support animals can be very problematic. Some people genuinely need emotional support animals. Others use it to circumvent particular restrictions and declarations. And this ends up being fights, causes legal battles for HOAs, and then ends up being very costly for POAs as well. So currently this bill attempts to correct that issue of these individuals who might just use a phony doctor's note to say, hey, yes, this is an emotional support animal. And if you look online, you can type in emotional support animal certification, and you could probably go buy yourself a letter from a doctor for $50. What this is trying to do is to essentially avoid people trying to circumvent restrictions. There are some issues here, though. Will the state actually want to pay for this statewide assistance animal registry? Moreover, will this particular state bill conflict with federal law? That is the biggest concern whenever it comes to this bill. And considering that we do like the idea of it, we'll be following this one very closely, and again, providing updates on the progression of this one.
Paul, I've got a question for you on House Bill 785. So we have this age, adding that to kind of a list of protected classes from a state law perspective. What about our plus 55 communities that basically federally are allowed to exist in the US and Texas as well? Does that affect those communities in any way?
It might. So right now, considering the actual bills, whenever it comes to the language of adding these protected classes, they're very limited. So that's why whenever Clint was talking about, just this adds this protected class, it definitely might. And as it progresses through the House, we will see how those issues are actually discussed and whether or not this one ends up passing. And
if you kind of review the federal law on plus 55 communities, it kind of recognizes the fact that, yeah, this looks a little bit like age discrimination, and in fact it is, but the purpose served by these plus 55 communities in terms of allowing older individuals access to social interactions, exercise, all that good stuff, all those great purposes for plus 55 communities more or less outweighs the discriminatory aspect of the plus 55. But as Paul mentions, there's definitely going to be an interaction. And if the bill passes, you've got to take a look at it. So really, really good question and good things to keep in mind.
All right, to continue on, the next bill, we're getting into the religious display bills, and these are very hot topics for both the House and the Senate right now. Of course, they're also very sensitive subjects. For House Bill 1569, this is relating to regulation by a Property Owners Association of certain religious displays. It was introduced by Schofield. The bill would prohibit POAs from adopting or enforcing a covenant prohibiting an owner from displaying one or more religious displays on the property. And this does delete the limitation of entryway. So potentially it could have the effect of people putting these religious displays all over their property. The bill also repeals the language under the current statute, which provides POAs with authority to regulate size and location concerning the religious items. Again, this is depleting the authority of the POA to regulate a lot of the aspects of religious displays in a community. The bill would also repeal the language under the current statute. Well, it looks like that one's actually been doubled. So going back to it, yes, they're taking a lot of the power away from the POAs when it comes to regulation of religious displays. And of course, POAs don't want to get in the way of a sincere religious belief and celebrating these holidays. However, at the end of the day, you can have people take advantage of particular bills like this and keeping things up all the time, and then also covering their yard in these particular with these religious displays. This might end up in community disputes, again, costly legal battles, or neighbor-to-neighbor disputes if you're potentially trying to sell your home and the front of somebody's property is covered in a lot of items outside.
So Paul, could you put a 30-foot cross in your front yard under the current wording of this bill?
So no. So for this one, well, if this one passes, then yes, you would be able to put something giant in your yard. The current statute would actually allow you to, or a POA, to regulate this. And that's why it's so important to see the fine language here of deleting the limitation of the entryway. This would really open the door for what I believe unintended consequences whenever it comes to passing this bill.
Paul, what about kind of the year-round Christmas decor idea, right? Because you're celebrating Jesus Christ.
Well, arguably what this bill is trying to do is whenever it takes away the POA's authority to regulate these things, then potentially you could have something like that. And I know that a lot of people already try to keep up Christmas lights year round, and that can be an issue within itself. But these particular bills, as stated, are really taking a lot of the power away from POAs to regulate these religious displays.
What about a association-owned common area? Would we still be able to prevent people from installing things on the common area?
Yes, I believe so.
Okay. That's it for the question, sir.
And the next one, this is the one that we're really paying attention to here. This is Senate Bill 581. And if anybody on the call participates in Rally Day, we will be discussing this bill with the legislative aides. This is relating to the regulation by a property owners association of certain religious displays. This was introduced by Betancourt, Creighton, and Colkhurst. This does amend section 202.018 of the Texas Property Code. It would ban POAs from enforcing or adopting a restriction that prohibits owners from displaying one or more religious items. Going back to the similarities between this one and the previous bill we discussed, and this would expand the statute, again, beyond the entry of the property. This means that if you would have, that 30-foot cross, it wouldn't have to be limited to the entryway here, and you could have it out there in the yard. And that can create many issues within itself. The POA could also enforce a restriction if the religious display threatens public safety, violates a law, is offensive, or is installed on property owned by the POA. Getting back to Clint's question, the POA may adopt and enforce restrictions relating to the size, material, and components of the display, and enforce limits on the length of the display if the item is relating to a religious event or holiday.
So, Paul, if you're in a community that is a no sign community and somebody wants to install a religious display sign, I mean, under those bills, would that be allowed?
It seems like it would, yes. And really coming to the crux of the issue with these bills, and we do believe that they are unintended consequences, is the fact that they are too expansive whenever it comes to the authority of having these religious displays out there on the property. Currently, the POA does have the ability to regulate the size and where it is, again, the entryway, but taking away these powers for a POA, it just might have those unintended consequences and people really taking advantage of the language of these bills if they are passed.
All good points on these questions, and defining what offensive means can be difficult as well. That's one question, is how do you define offensive? And that's very subjective. So you're adding subjectiveness to a statute that can always lead to conflict between the owner and the association seeking to enforce its rules and regulations.
Definitely. Going back to just the fact of it's a very sensitive subject, and that's why it can get very ugly whenever somebody might say this is offensive. Somebody else says, no, it's not. Well, at the end of the day, it's a he said, she said argument.
Paul, they're asking, one participant's asking what TCAA's thoughts are on those two bills.
So our thoughts are that they're overexpansive. We're going to be trying to work with the legislators to amend these particular bills to really limit the amount of the religious displays that can be displayed. And essentially, we're opposing most of this language in these bills.
And so, Paul, do you think they've got some traction to your knowledge?
We don't know yet, but we will be discussing it this week. As I stated, if anybody wants to sign up and register for Rally Week, we will be on these calls discussing House Bill 581 in particular. And if anybody who's registered has a particular scenario that they might like to discuss with the legislators, then again, I do encourage you to please contact me and I can get you that information to register for Rally Day. And
it's the email is going to be included, but it's pgaines, P as in Paul, GAINES @rmwbh.com. All right, let's move on to swimming pool enclosures. So this actually would prohibit an association from enforcing any kind of provision that has the effect of prohibiting or restricting an owner from installing a swimming pool enclosure that conforms to applicable state or local safety requirements. Look, we already have requirements in place that specifically allow or require owners to enclose their pool. By adding this type of a law, what's the limit? So you could install a 30-foot swimming pool enclosure with all of the mosquito netting completely surrounding it. And as long as it complies with state requirements, the association can't do anything to prevent it. Versus a fence that complies with state law requirements and also complies with the association's fencing regulations. So again, this one's something that could lead to some unintended consequences and really tie the hands of those communities who have areas that need to be aesthetically pleasing, maybe because they're on a lake or they abut certain common areas or golf courses. So again, something to watch and be aware of. Golf carts, Senate Bill 206 and House Bill 1281 is the companion. And this one basically fixes the problem that the last legislative session kind of imposed unintentionally. It required all golf carts to be licensed on any and all roads in the state of Texas. So we've got a lot of master plan communities that are also golf cart communities. And in reading that statute that was adopted last session, it required those golf carts to get license plates, even though you were on very minor thoroughfares. So this kind of creates an exception for master plan communities. And that's pretty much it, as long as it meets the definition of residential subdivision.
Okay, quickly, let's discuss the motor assisted scooters bill and then the bill relating to the records of certain condominium unit owner associations. So under House Bill 934, this was introduced by Raymond. It amends 551.351 and 551.352 of the Transportation Code to allow a person to operate a scooter in a bicycle lane or on a street or highway. County municipalities can further restrict the speed, location, impose minimum age requirements, impose higher penalties, restrict parking, and or require safety helmets. Only one person can ride and must yield to pedestrians. And the reason that we are including this particular bill is that it really could affect communities that have public roads and maybe they live in a portion of the city that sees a lot of motor scooter people riding around on the streets. I know that in San Antonio, they're very popular. I know in Austin, they're very popular. Clint and I have actually discussed these issues on multiple occasions whenever it comes to the scooters. But what I'd like to see on this one is just a POA's ability to create rules and regulations regarding these scooters in their communities, because they can become a nuisance. They can be dropped off You can have people riding on the roads. So I would like to see some kind of amendment allowing POAs to regulate the motor assisted scooters. Senate Bill 318. This one would essentially mirror 209.05, the Texas Property Code, and make the association record statute applicable to condominiums. This would include the deadlines, any timeframes provided under that statute, and then also what has to be included and what doesn't have to be included. And oftentimes, whenever a condominium might get one of these records requests, we might say, looking at 209, it's not a bad idea to follow some of the rules under 209. So if this does get passed, it's not too much of a worry. It might add a few more complications to condominiums, but at the end of the day, if there is a records request, having a time frame on those requests is not that big of a deal. House Bill 1467, relating to property owners associations annual meetings held electronically. This is actually a pretty good bill. Currently, Chapter 22 and 6 of the Texas Business Organizations Code allows these meetings to be held electronically. What this particular bill would do is just put that in under 209, making it very clear that annual meetings can be held via electronic or telephonic means if each attendee may hear and be heard by everyone attending. And then again, you have to have the notice that's sent to members, including the instructions to access the communication method required to attend the meeting remotely. Because of COVID-19 and the ongoing pandemic, many associations have been forced to use virtual meetings and have their annual meetings electronically. Oftentimes it can actually be more convenient. It can be less costly for these associations. So having this reflected under 209 might be a good thing in the long run. Again, even though Chapter 22 and 6 of the Texas Business Organizations Code provides for these electronic meetings, if it's found under 209, it would be nice to have that language under there as well.
Paul, quick question for you on that electronic bill introduction. What about condos? How do condominiums hold electronic meetings?
Yeah, so condos are a little trickier of a question. It's always subject to the governing documents. You typically won't find governing documents that provides that you cannot have those meetings electronically. But this one right here, of course, it wouldn't apply. It would only apply to 209 if this bill was passed. But arguably under Chapter 22 and 6 of the Texas Business Organizations Code, those meetings can be held electronically.
And I think there's a comment here about these electronic meetings. All members can hear and be heard. So does that mean that all owners have to be able to speak whenever they want to, which in turn means you could get a meeting out of hand fairly quickly if you don't have some way to regulate? So I think there'll be a balancing act, and we'll see how the bill, whether or not it gets any traction. But even if it doesn't, Chapter 22 has some requirements as well. So if you're looking at having electronic meetings, be sure to consult with your counsel on how members should be allowed to interact.
Agreed.
All right, fining. House Bill 2076 relates to the filing of a property owners association fine policy with a municipality. So first point we want to make is if the association has a fine policy, Chapter 202 of the Texas Property Code, which applies to condos and single family communities, already requires the association to file the policy in the real property records for the county where the property is located. So we already have a filing procedure in place, number one. Number two, what area of the municipality would you file it with? It's not like county real property records. There currently isn't anywhere to file with a municipality. So if this bill were to pass, all municipalities would have to set up some new registration and filing system, which obviously would cost a lot of taxpayer dollars. So again, that one doesn't necessarily make a lot of sense because we already have some protections in place for filing governing documents. The other one, House Bill 1970, again relating to fines. And this one's been seen, we've seen this, I think maybe 2 or 3 previous legislative sessions, and it basically requires the association to adopt a fine policy, and there's certain requirements in terms of what the policy has to have. Again, our general recommendation and most association attorney recommendations is if you want to levy fines and it is not specific in your governing documents what that fine amount can be or should be, then you have to adopt a fine policy, and that fine policy has to be recorded. So we don't really think this is a necessary addition, because under current law, it's more or less required. All right, other new bills relating to the foreclosure of assessment liens on certain boarding home facilities. And again, it allows a POA to judicially foreclose an assessment lien on a property used as a boarding house if the debt securing the lien consists solely of fines assessed by the association for a violation of the governing documents, and the violation constitutes neglect or abuse of a resident of the boarding home facility. So currently, an association cannot foreclose on amounts consisting solely of a fine. So this would allow a little bit more wiggle room when associations are having to deal with boarding home facilities, which are currently allowed in community associations across the state of Texas. House Bill 1383 relates to the authority of entities and individuals to prevent individuals from accessing private property for the purpose of registering voters or communicating political messages. This would prohibit a community association from adopting or enforcing any kind of governing documents that prevents people from knocking on the front door, leaving pamphlets, other sort of information regarding political measures, political parties. So basically, this would allow people in any community, whether it's gated or open public streets, to come in and give political messages, pamphlets, other information. And then again, here's the exception. The POA can adopt or enforce a restriction on the time, place, and manner of such activity. We just can't prevent it. So really opens the door for a lot of private communities, because there's not a lot community associations can do in open communities, but gated communities, you just don't let them in. So it could cause some problems down the road.
Okay, getting to the chicken bill, everybody's favorite bill that we have seen in past sessions. Here it is again. This time it's a little more expansive whenever it comes to the different animals provided under the bill. So this bill would prohibit a POA from adopting or enforcing a restriction that prohibits the growing of fruits and vegetables, the raising or keeping of 6 or fewer domestic fowls, 6 or fewer rabbits, or 3 or fewer beehives, or a cottage food production operation on a residential lot. This is a very strange bill. And just reading it, you can think of all the issues that would come with having all of these animals on one particular lot, especially in smaller lot communities. So the bill would allow a POA to adopt or enforce a covenant to impose quote unquote reasonable requirements on the raising or keeping of fowls, rabbits, or beehives, such as placing a limit on the number of the animals or beehives as above the minimum included in the bill, prohibiting the raising or keeping of a rooster, or the minimum distance between an animal shelter or beehive and a residential structure. As I stated, this bill comes with a lot of issues, and we are definitely against this one. Having chickens, rabbits, beehives on a smaller lot property or on any property would increase odors, noise, other related nuisances, escalate neighbor-to-neighbor disputes. You also have the issue of many people being allergic to bees, and you have children playing outside in communities, and you have these bees in people's backyards. It also may lower property values and affect home sales. And the reasonable requirements is very ambiguous. We believe that might lead to potential liability and then also legal battles down the road.
I mean, Paul, let's do a hypothetical, right? You've got 10 homes, they're facing or they're backing up to each other. That's 120 chickens
Yep.
over a very, very short area. Talk about odor. It definitely would have some unintended consequences.
Exactly. House Bill 2447, relating to the recall of a board member and suits against a property owners association. If passed, this would permit an owner holding at least 20% of all voting interest in a POA to petition the POA and require a special meeting to conduct a recall election to recall a board member. Within 90 days of the POA receiving the petition, the POA is required to hold the recall meeting, and if a majority of votes in the recall election are for the recall of the named board member, the member's position is immediately vacant and the board shall fill the vacant seat. Again, this is one that I believe is unnecessary. Most associations already have removal provisions in their governing documents. I also believe that the threshold of the 20% is quite low, but it seems like this was just passed in order to give members another avenue to remove board members. But as I stated, I believe that it's unnecessary. Most governing documents already address this for communities. House Bill 1659, relating to the amendment of a residential subdivisions declaration to affect certain types of properties located in the subdivision. And this bill would amend section 209.041 of the Texas Property Code, and that's the requirement for the 67% vote for a declaration amendment. And it would add one subsection, that's D1. This would be the 67% vote requirements would not apply to an amendment that affects a portion of a subdivision zone for or containing a commercial structure, industrial structure, apartment complex, or a condominium. Small little change in under 209. And considering that it does affect 209, of course, we wanted to discuss it today, but not too many issues coming from this one.
All right, here's another one. House Bill 1963. It relates to the regulation of short-term rentals by a property owners association. And quick comment, these are all bills, right? They are not the law. They're all being looked at by committees, being voted on in the House or Senate respectively. So again, it's not what is, it's what may be. So just want to make that clear. We had a couple folks commenting on that. So back to House Bill 1963. It adds a new section to Chapter 202, which applies to both community, single family, and condominiums, and it allows the POA to adopt or enforce a provision in a dedicatory instrument that regulates the use of property as a short-term rental. It goes on to define that as a short-term rental as a residential property rented for a fee for a period of no longer than 30 days. So again, this bill actually gives the association a little bit more regulation rights as it relates to short-term rentals. All right, House Bill 2013, Senate Bill 359, relating to a provision of a verified accounting for actions involving foreclosure of a lien on residential real property or recovery on a consumer credit account. And it requires the applicant for an expedited order allowing foreclosure of a lien on residential real property or a petitioner in a judicial action, a lawsuit. So you've got expedited foreclosures and you've got lawsuits to file along with the action a verified accounting. So verified accountings basically mean the custodian of records for that accounting has to swear or attest to the accounting. So again, just another step in the process. The association, single family communities already have to comply with, filing a lawsuit or an expedited action. Accountings are already attached. The attorney fee affidavit, the attorney swears to their fees already. So this would just be an additional step, one more thing that kind of adds more costs to trying to collect assessments. Mr. Gaines.
House Bill 2274. So as we previously discussed, a lot of the discriminatory provisions are found in the very, very older restrictions. This particular bill is trying to correct that and also give these older subdivisions an avenue to go ahead and remove those discriminatory provisions. This is relating to the extension or amendment of deed restrictions in certain older subdivisions. So it proposes to add a Chapter 216 to the Texas Property Code to provide a procedure for extending or amending restrictions for pre-1950 subdivisions. So very, very old restrictions. This would include the removal of any restriction related to race, religion, or national origin that is void and unenforceable under the United States Constitution or Section 5.026. As Clint previously discussed, if you have a discriminatory provision under 5.026, it's already unenforceable. What most of these discriminatory bills are trying to do is just completely remove or redact those from those documents. So this particular bill is quite lengthy. It does discuss the consent required for the extension of the amendment. This would be 66.6% of the owners. It does discuss the petition ballot requirements for the extensions of the amendments, and then also the effective date of the extension or the amendment if it is passed. House Bill 2387. This proposes to add a Chapter 31 to the Texas Property Code, which would address suits to collect past due POA assessments. Clint's already discussed one of these collection assessment suit bills, and it seems like this is also another hot topic for this particular session. So this bill would apply to Chapter 209 property owners associations. That would be subdivisions and townhomes. It would give JP courts exclusive jurisdiction over POA collection suits and also provide requirements for the petition. Going back to that verified accounting, you also have to discuss steps taken to comply with Chapter 209 in the governing documents, and then it limits relief only to what's discussed in Chapter 31. So this is really, if this were passed, this would really change the way that collection suits are filed. This also sets forth counterclaim requirements for an owner and does permit a JP court to order mediation at no cost to the property owner. So you could be in a lawsuit and mediation could be ordered. And at the end of the day, the association wouldn't be able to recoup their costs for that mediation. It also allows JP court to permit an owner to pay a judgment within 30 days or even submit partial payments to satisfy the judgment. So this is very debtor friendly, this particular bill. It permits a court to award attorney's fees in an amount that does not exceed the greater of 15% of the amount the POA is seeking, or $500. Many times these collection suits can be very expensive. And at the end of the day, this is going to deter POAs from filing these suits and then also trying to collect these past due assessments if at the end of the day, you can only recover a small portion of those attorney's fees. Provides that a judgment in favor of the POA that has become final is the only basis to record a lien based on the unpaid assessments, and also provides limitations on notice of liens and list pendants. So as you can see from this bill, again, very debtor friendly. This would definitely be one that we would oppose.
And again, to Paul's points, that bill kind of has the effect of preventing associations from effectively collecting the amounts due and owing. So what does that do in turn? Well, it forces the POA to increase assessments overall. And that makes the people who are paying have to pay more to subsidize or carry those owners that are not paying. Foreclosure is a very rare remedy used, at least with our law firm. And I feel fairly confident that other law firms practicing in this area in the state of Texas would also have a very, 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 very low percentage of accounts that actually go to foreclosure. So it definitely has some consequences that would affect the POA industry across the state of Texas. All right, House Bill 2912. It adds a new section to Chapter 209, again for subdivisions and townhomes, 209.017. And it basically says that if a board member violates Chapter 209 or a governing document while wearing their board member hat, an owner can file a petition against the association in JP court. And if the owner wins, the judgment may provide that the POA remove the offending board member, award damages, or authorize a reduction of assessments based on the damages awarded. And it requires the owner to provide 10-day notice to the POA prior to filing suit. I mean, this is just asking for lawsuits. There's going to be lawsuits left and right in those types of instances where owners feel like a board member or the board as a whole did something wrong and decides to file suit. The owner then has to get their insurance carrier involved. The insurance then has to defend the matter. Win, lose, or draw, the association is out money because insurance rates go up. When you have to notify them and they have to get involved over and over and over again, they're either going to drop you or they're going to increase their rates so much that you have to go to one of those B-rated insurance providers. So again, unintended consequences. I understand the idea behind it, but hopefully most of your communities out in the state of Texas are represented by management companies and have general counsel that get involved and advise the board when the board does something that is not in compliance with state law or the governing document. So this is one of those types of situations that it would, again, not be good for the community association industry as a whole. And I will, last but not least, Mr. Gaines, take it away, sir.
House Bill 3367. So this is relating to the powers and duties of property owners associations authorizing a fee. This bill proposes to make Chapter 204 of the Texas Property Code applicable to all communities governed by Chapter 209. So right now, Chapter 204 is bracketed. If this were to pass, then it would apply to all communities that are subject to 209 subdivisions and townhomes. The bill would prohibit a director from serving on the ACC. This would have a detrimental effect to a lot of the communities that don't have a lot of volunteers to be on the board or the ACC. The bill seeks to amend Section 207.03 of the Texas Property Code to place a cap of $250 on resale certificates and a $30 cap for an updated resale certificate. So huge impact on the POA industry across Texas if we had these cap fees. Credit bureau reporting would be banned if the owner has a pending dispute of the charges with the association. Would also amend hearing requirements and provide that a POA must, no later than 10 days before the hearing, provide an evidence packet to the owner. Also removes the provision under Chapter 209 permitting a POA to require a copy of the lease, of course, with the redactions, to be produced to the POA. So this one really is trying to take away a lot of the authority of POAs. And at the end of the day, I believe it's altogether detrimental to POAs, and I would oppose it.
Yeah, there's all kinds of stuff on this one. I mean, it's addressing a wide variety of topics. And to Paul's comment that 204 is bracketed, that means it pretty much only applies to counties meeting the definitions to be applicable to Chapter 204. And you're pretty much looking at the Houston Metroplex for Chapter 204 applicability. All right. So as y'all noticed, so many questions came in. Paul and I kind of stopped looking or addressing them. So luckily, we've got about 7 minutes to address them. So let's get going. Question number one, is there currently any liability for the association if an owner does not enclose the pool with an enclosure or fence? So again, current state of the law, owner has a pool in their backyard, owner fails to enclose a pool or fence, somebody gets injured, and does the association have any liability for failing to basically try to enforce a fence requirement in the backyard? Paul, anything on that one, sir?
Well, I think arguably people can sue HOAs for anything these days, right? They think the liability is going to be found anywhere. Whenever it comes to these pool enclosures, I know that it has a big effect on your insurance, of course, but whenever it comes to maybe individual drowning in the pool, then somebody might try to point the finger at a POA.
And would any kind of liability change if that pool enclosure bill passes? Or would it stay the same?
It really depends. Whenever it comes to that pool enclosure bill, again, it allows anybody to put up whatever they want around that pool whenever it comes to fence enclosures. But I believe that liability wise, it depends on the governing documents and really the particular circumstances of what occurs at the pool.
Thanks, Paul. Slides will be provided to everybody. We just have to get everything looking in good shape before we provide this PowerPoint, provide this presentation. Another question, House Bill 1467. Let's see. Is there any language about holding the vote about holding the vote for the online meeting. I think this is the bill, Paul, relating to the ability for a board, for a community association to hold electronic meetings for subdivision and townhome. Any kind of language about how the vote is to take place?
I don't believe so. I mean, it'd be great if there was something giving us instruction on that, but it's a pretty limited bill.
But the good news is there's already a section in Chapter 209 specifically authorizing the association to allow for electronic voting as long as certain requirements are met. So we've already got a little bit of assistance there. So I think reading them together along with Chapter 22, your counsel should be able to give you clear direction on how to do it the right way. All right, another one here for electronic, Paul. To what extent must members be allowed to speak?
So as Clint discussed, you can't run an effective meeting if everybody is just chatting it up on the electronic annual meeting. So there has to be some kind of regulation to where people speak, whether that's setting up an owner forum at the beginning or the end, taking questions throughout. Luckily, the platform such as Zoom does allow people to put things in the chat bar or also raise their hands. So there's an organized fashion to do it to where everybody is just not talking all at once. Of course, if that happened, you would get nothing done.
Very good point. So again, work with your counsel. He or she should hopefully be able to give you some good guidance on what's okay and what's not. What about deaf people for virtual meetings? How can we effectively have a virtual meeting for a deaf person? I haven't had this issue arise yet, but here's typically how it works. So a deaf person is somebody with a disability that affects one or more of their daily life activities. So when a deaf person asks for some sort of an accommodation from the association, typically the association has to provide a signer, somebody who's, who can do sign language so that the deaf person can watch. I would imagine for a virtual meeting, you would need to basically hire a signer to participate on the virtual meeting and do the sign language. And, it is a cost that, again, Paul, you may remember this, my memory, if memory serves, it is a cost the association has to pay. It is not a cost the owner has to pay. Is that your understanding as well, Paul?
So.
Yeah.
Yes. And it is a very difficult question. It's a great question. And as Clint said, it really comes on a case-by-case basis, but it can be very difficult to address. But of course, if there is somebody asking for that accommodation, we want to make sure it's addressed.
Annual meetings, another question, annual meetings for POAs normally entail meeting just for electing the board. Does this bill kind of address that task? Yes. Again, we already had authority for electronic meetings under Chapter 22 of the Texas Business Organizations Code. This allows for more of a belt and suspenders approach. So, ooh, Paul, what is a cottage food operation? It's when you make a lot of cottage cheese, right? No, bad joke.
That's a good question. I'm really not certain exactly what that is or what that entails. Would that be a large hut in your backyard, a shed where you make cottage food production? That is a very good question. It'd be nice if that was defined under the bill, but without researching that particular subject, I don't think that I can really tell you exactly what that is. But after this presentation, you've sparked my interest. I'm definitely going to do that.
Do you have to file with a municipality if you're not within their city limits? No, you do not. Only municipalities that you fall within. Is the old chicken bill allowing chickens, rabbits, beehives per lot or per person, Mr. Gaines?
It's going to be per lot.
Per lot. Would associations that already, sorry for the question, we don't know what that one relates to. Does this mean anywhere on the lot? So this is kind of the chicken stuff. Example, would a restriction against vegetable gardens in the front yard be forbidden if this passed?
Well, see, that's a good question. And that's where a lot of the ambiguity in the bill comes from. Really where the POA can regulate and where they can't. That's why whenever it states the reasonable requirements, well, what is reasonable? And whenever this bill passes, if it does, and things end up in a legal battle, those are what we're really worried about whenever it comes to this particular bill, is the ambiguity of it.
Next question, does the 67% amendment, 209.0041 apply to commercial POAs? The answer is maybe. Again, get with your counsel, and he or she for that particular commercial POA can take a look at it and determine whether or not it's going to apply. Portions indicating that a director cannot serve on the board and on the ACC. Is it a good idea? The ACC should be a training ground for board leadership. So look, I'm not saying that if everything was ideal, it wouldn't be good to have some separation between the board and the ACC. The problem is, for many communities across Texas, you can't find the volunteers, right? Your volunteerism is very, very limited. You try to get people to give back, and it is just not happening. So in those types of situations, the board should be given some latitude where that board member may have to wear the board member hat and the ACC hat. Under HB 3367, would the chair of the ACC committee be prohibited? Yes, basically under the current wording, you cannot be on the ACC and the board. Another question on the resale certificate limit, and it's more just a statement. For online meetings, how do you handle proxies? Paul, how do you handle proxies, sir, for online meetings? Do you recommend them?
I do not. There's definitely different avenues to be taken whenever it comes to the online meetings or the online votes. And any time that an association is planning on moving forward with an annual meeting, even an online board meeting, I do recommend getting with counsel, because a lot of times the governing documents can be a little confusing whenever it comes to the procedure. And, Clint and I have handled these many times, so I would definitely recommend getting with your attorney, getting recommendations before proceeding, especially if it's going to be a vote.
All some really good cottage food definitions, but basically it's a person making different foods with an income level that's fairly low. It's kind of a farmer's market idea. So that's
okay.
Cottage food industry. A bunch of definitions on cottage food.
This is great. Thank you all very much.
And I think, unfortunately, we are out of time. So again, if you didn't get your answer, your questions answered, and you want some help or some additional guidance, you've got Mr. Gaines' email. My email will be provided as well. Feel free to reach out to us. And again, thank you all for participating today. I hope you learned a little bit. Again, these are merely bills. We're at the halfway point. TCAA is working tirelessly to address a lot of these issues and concerns, as long as other, our law firm and other attorneys across the state of Texas. So with that, thank you very much. Bye, everybody.